Welcome everyone to our 2022 Saferstein Lecture. My name is Kevin Thompson. I'm Associate Dean of Development here for the College of Science at Northeastern University. Very excited that you're all joining us today and very excited to have our honored guest, Judge Nancy Gertner here, who will be giving us a presentation. Just wanted to go over a bit of housekeeping before I turn it over during this virtual format. Judge Gertner will start her presentation in approximately 10 minutes. But if we could have all of our questions, there'll be a time for questions at the end. If we could put those all in the chat, I'll try to narrate those so there's not fumbling amongst all of our people trying to unmute themselves and so on and so forth. So if you could put those in the chat, I'll try to read those out to Judge Gertner. Without further ado, I'm going to turn this over to my colleague, Erin Cram, who will start introductions.
Good afternoon, everyone, and welcome to the 2022 Saferstein Lecture in Forensic Science. My name is Erin Cram. I'm the Associate Dean for Research in the College of Science and a Professor of Biology here at Northeastern University. So really glad you can all join us today, and of course, welcome to Judge Gertner. So tell you a little bit about Dr. Saferstein and the award and his life. So his personal life was really an inspiration. He was the director of New Jersey State Police Crime Lab for over 20 years. He worked with a large team of scientists to analyze over 35,000 cases a year. And his skills led him to being an expert witness in court over 2,000 times. From fire debris analysis to testing pharmacological effects of alcohol and drugs to the forensic examination of evidence such as blood and glass, the job not only kept Dr. Saferstein busy in the field, but also as an author. He wrote many papers for the forensic science field, 5 books, and many of them are the standard forensic science texts used today. Additionally, Dr. Saferstein served as an editor for many professional reference books and brought his expertise to professional organizations such as the American Academy of Forensic Sciences, where he was a fellow. In 2006, he was awarded the Paul Kirk Award for Distinguished Service and Contributions to the field of criminalistics from this academy. For Dr. Saferstein, Northeastern University and the Barnett Institute of Chemical and Biological Analysis have been familiar ground for many years. Through his many years working with Northeastern, Dr. Saferstein developed strong relationships with many colleagues here, including Dr. Barry Karger, Dr. Adam Hall, who's with us, Dr. Ira Kroll, Patty Flint, and many more. In 1998, in collaboration with the College of Criminal Justice and through the Barnett Institute, Dr. Saferstein established the Francine and Michael Saferstein Memorial Lecture Fund, with annual lectures beginning 3 years later. In memory of his first wife and 3-year-old son, who died in 1973 in a tragic incident at their New Jersey home, Dr. Saferstein started this lecture series with the goal of emphasizing the importance of forensic science within the criminal justice system. He intended to use this lecture series to be flexible and unique, allowing lecturers outside of forensic science to come and share work that could impact the community. So today we have a glowing example of that with Judge Gertner's presentation. So the 2022 Saferstein Award in Forensic Science recipient is Judge Nancy Gertner. Judge Gertner is a graduate of Barnett College and Yale Law School, where she was an editor of the Yale Law Journal. She received her MA in political science at Yale University and has been an instructor at Yale Law School, teaching sentencing and comparative sentencing institutions since 1998. She was appointed to the bench in 1994 by President Clinton. In 2008, she received the Thurgood Marshall Award from the American Bar Association section of Individual Rights and Responsibilities, only the second woman to receive it. Justice Ginsburg was the first. She became a Leadership Council member of the International Center for Research on Women the same year. In 2010, she received the Morton A. Brody Distinguished Judicial Service Award. And in 2011, she received the Massachusetts Bar Association's Hennessy Award for Judicial Excellence and an honorary Doctor of Laws degree from Brandeis University. In 2012, she received the Arabella Babb Mansfield Award from the National Association of Women Lawyers and the Layla J. Robinson Award of the Women's Bar Association of Massachusetts. She has been selected to receive the Margaret Grant Women Lawyers of Achievement from the American Bar Association Commission on the Status of Women in the Profession in August of 2014, and has been profiled on a number of occasions in the Boston Globe, the ABA Journal, Boston Magazine, and the Wall Street Journal. So Judge Gertner has written and spoken widely on various legal issues and has appeared as a keynote speaker, panelist, or lecturer concerning civil rights, civil liberties, employment, criminal justice, and procedural issues throughout the US, Europe, and Asia. Her autobiography, In Defense of Women, Memoirs of an Unrepentant Advocate, was released on April 26, 2011. Her book, The Law of Juries, co-authored with attorney Judith Minzer, was published in 1997 and updated in 2010. She has published articles, chapters, and other works on sentencing, discrimination, and forensic evidence, women's rights, and the jury system. In September of 2011, Judge Gertner retired from the federal bench and became part of the faculty of Harvard Law School, teaching a number of subjects, including criminal law, criminal procedure, forensic science, and sentencing, as well as continuing to teach and write about women's issues around the world. Gertner is presently working on her second book, Incomplete Sentences, concerning the men who she sentenced over her 17-year career as a federal judge. In addition to writing about them, highlighting the unfairness and disproportionality of their sentences, she is assisting in clemency petitions where appropriate. Judge Gertner joins an illustrious group of over 20 past recipients of this recognition, many of whom are with us, and we are so pleased to have her here with us today. Given that we are convening virtually this year, we have sent Judge Gertner her award in the mail. Welcome and congratulations, Judge Gertner. I'm so excited to hear what you have to say, and my warmest congratulations on this award.
Thank you very much. Do I begin?
Yes, I think so.
Okay, good. I'm delighted to be here. That was a resounding introduction. I have to admit, I was worried at first about blurring my screen, and then now I realize that I'm talking to academics. So my desk, my sloppy office will look familiar to you. When I speak to senators, they of course have the ceremonial office. I had a ceremonial office as well. They asked me, they would decorate an office when you become a baby judge. They gave me a budget. I said, all I need is surfaces. That's all. In due course, you won't be able to see that wonderful credenza or that wonderful couch. And of course, that's what happened. So I'm happy to be here, and I'm happy that you can see my office. So I call this the judicial science disconnect. And let me start off by suggesting why I cared, how I came to this. And that it's more than just a question of my honors, how I came to this. I was a criminal defense lawyer for over 20 years. What that meant that I had the experience of having a handwriting issue in a case and going to the person in Boston who was in charge, who was the expert on handwriting analysis. And she literally asked me two questions. What side are you on, and can you pay? So as a criminal defense lawyer, I knew immediately the ways in which forensic science was skewed, the ways in which it was not examined, the ways in which either side could use it for whatever purposes. I was teaching evidence while I was practicing. I've always taught and practiced. Then I went on the court. And on the court, although the federal court does not have the kinds of cases that the state court has, murders, robberies, etc., I had numbers of instances in which I was dealing with forensic evidence and troubled by what I saw, troubled in the ways that I'm going to describe. And then since then, I teach evidence and this whole package of stuff. Why have the courts been slow to address problems with forensic evidence? That's the purpose of the gist of my talk today. It's particularly relevant to this group because you will think that science should win out, that scientific validity should win out, and that it should win in, obviously in the world, but it should also win in court. And that actually hasn't happened with respect to forensic evidence. This is a quote from Jennifer Mnookin, who describes the ostrich approach to what most courts have done with forensic evidence. There are some changes, which I'll get into. Pretend there's no problem. Pretend that the academic and National Academy of Science critique didn't happen. Ignore the implications for defendants' liberty of the uncritical admission of forensic evidence. But ironically, after the TV program CSI, numbers of judges were grappling with what to do about the CSI effect, give instructions about it. It turns out there was really not much to it. There was no, CSI was this program on television where it was actually a riot. That someone would show a piece of dirt, and then they would have some kind of gadget that invariably was ultraviolet, and they put it on the dirt, and they would suddenly solve the case. And so the notion was that people were believing that in every case, the scientific data would win out. In fact, it didn't last very long on television. It wasn't very much of an effect, but more attention, more cases. If you run a review of the literature, more cases would be devoted to the CSI effect than to challenged forensic science. The National Academy of Science wrote a report in 2009, which you all are probably familiar with, very high level group of participants, very high status report. And the report questioned whether the underlying research in forensic science justified the claims that they were making, specifically talked about fingerprint, handwriting, tool mark, suggesting that in many cases, conclusions were not supported by the methodology, that evidence was introduced in court that had not been, that was based on science, that had not been peer reviewed or had any published studies, that there were no meaningful proficiency performance measures, and that in fact, in many of these cases, there was no basis for individualization, no basis for saying this crime scene evidence links to this individual. And I might add, certainly not in the way that this testimony was presented. And I was in court when forensic scientists would say this bullet fragment matches the gun that was found on the defendant to the exclusion of all others in the world. So it was a powerful report. It suggested major problems. 2016, a report that I participated in, President's Council on Forensic Science and Technology, went even further and really highlighted particular trace evidence, feature comparison, forensic evidence, and their deficiencies. And in particular, I might add, focused on bite mark as essentially having no basis, whatever the presumption that a bite mark that skin bite mark records precisely what the dentition of the biter was, had no basis, in fact. With respect to some of the others, it was an issue of the methodology. It may have been an issue of proficiency testing, but bite mark was saying clearly there was not any basis for a scientific expert testifying on that. But then it turned to the courts. Both reports talked about the evidence and then talked about the courts. The NAS report 2009 said courts have been utterly ineffective in assessing the research bias for forensic science. The PCAST report said that federal judges should do better about considering the appropriate scientific criteria for assessing validity. I actually that was a much more gentle version of what the report was saying. So both the NAS report and the PCAST report 2009, 2016 are saying to judges, there are major problems with these areas, not necessarily irreversible problems, but major problems in these areas. And you need to look more closely. As I said, the problem is sometimes there was no field, no scientific basis for the conclusions of bite mark testimony. In others, it was a question of no proficiency testing. In other areas, it would be no peer-reviewed studies, but there are problems here, courts, you should pay attention to. The Innocence Project has, over the past 20 years, approached the issue from the other perspective, DNA exonerations, evaluating then who was exonerated by DNA evidence, and then looking back and saying, what was going on in those cases that we might want to look at and consider and say, what was the problem? DNA affected the exoneration, but we could go back and say, how did it happen that there was a wrongful conviction here? And they found 50% of the DNA exonerations had forensic science that was improperly admitted. So my point here is to suggest that by 2009, 2016, and a drumbeat over the past 20 years, courts should have gotten the message that there's forensic evidence, not all the time, but it needed to be examined. And I've spent to some degree the past 20 years understanding why that hasn't happened. What happened in the courts after the national reports? The answer is not much. And I wanted to try to understand why that was so. Let me start with a case, United States versus Pena. I won't do much law. I'm going to give you a little description of it. This is a case that came down as I was on my way to a conference on the National Academy report and why the courts had not paid attention to it. And on the plane, I learned that I was affirmed for deciding not to hold a hearing on fingerprint evidence. I'll get into what that means. The problem was, of course, I had decided to hold a hearing. I was affirmed for doing something which I, in fact, had not done. And I'm going to go into this case a little bit because it shows the blinders that judges have that resist reevaluating, particularly evidence that's been introduced for years. So lawyer files a pretrial motion. The case is a felon in possession of a firearm. The story was the Pena was a felon. He sees the police, had a prior record rather. He sees the police coming at him. I don't remember the initial circumstances. He runs across a field. Police see him drop something. And after they apprehend him, they go back and pick up the gun and test it for fingerprints. And they determine that the fingerprints on the gun was that of Mr. Pena. The lawyer files a motion to exclude the fingerprint testimony. Now, this may seem like a minor detail last minute, right? On the eve of trial, please exclude the fingerprint testimony in this case. It was a one-page motion. It cited a law review article from a law student. It didn't cite the National Academy report. It didn't cite the robust studies that had been done, not on the, on the limitations of fingerprint testimony in certain cases. It didn't cite any of that. It was obviously a lawyer who was sort of throwing out a motion at the last minute. The judge, me, I scheduled a hearing. I had absolutely no, I could have easily turned him down. What he had given to me was just really insubstantial to trigger a hearing. Hearings are not automatic on the evidence in a case. Hearings to determine admissibility are not automatic. Typically, a lawyer has to tee up the issue. They can tee it up before trial. They can tee it up during trial. He teed it up, in a sense, right on the eve of trial. So I schedule a hearing. At the start of the hearing, I have the government lawyers outside. I have the defense lawyer, the government witnesses rather, were ready to come in. They were outside the courtroom. The lawyer comes forward. I say, okay, go. He says he had no witnesses. He said he had no experts. He said the motion had only been made, quote, for the record. And then he added, with all due respect, Judge, I appreciate that the court gave me more credit than I deserve. This is a moment when I, as a judge, actually wanted to say much, much more than I said. And some portion of it may not have been clean. I appreciate that the court gave me more credit than I deserve. His client was on trial. He was before a judge who, by this point, I had issued numbers of opinions on forensic evidence. He was before a judge who would have credited this and given him a hearing. And he said, I have nothing. The court, slow to anger, infinitely patient. I wish I could have found a comic book figure that would show, smoke coming out of my head. I then outlined for him the nature of the criticism of fingerprint testimony. I provided him the cases. I outlined for him what he should have done. I outlined how seriously I took these cases and about my prior rulings on handwriting and ballistics. And then I invited him to challenge the evidence. He says, "No, Judge, I'm good." We'll get to a moment about what a judge can do. It was a wonderful commercial when I was a child. I remember, maybe it was more recent than that, where at some point in the commercial it said, "What's a mother to do?" This was a moment that I felt like that. What was I to do when he was refusing to challenge the only evidence in the case? At trial, the fingerprint testifies to a match. He's cross-examined by the defense, and the defendant is convicted. I don't hear about the case afterwards. Case goes on appeal, and I am thunderously affirmed. I put it that way because usually that's a moment of great celebration, right? The Court of Appeals thinks you did the right thing. I have to admit that I oftentimes didn't much care what the Court of Appeals did because I was sufficiently egomaniacal to believe that I was right and they were wrong. But here I'm thunderously affirmed, and I'm reading this affirmance on my way to a conference at which I'm going to talk about why the National Academy report is not implemented in court. The National Academy report also included a critique of fingerprint testimony. I think, oh my God, I'm now affirmed. I'm about to go into this hearing, this conference. On what basis was I affirmed? Point one, that put the obligation on the court to be a gatekeeper for forensic evidence. So I was right to conclude there was no need for a hearing because the hearing could be restricted only to novel challenges. That's not true. I did not believe, and I've made it clear on the record, that it didn't have to be a novel challenge to existing testimony, that it wasn't about the novelness of the challenge. If the challenge was appropriate, it was appropriate, and I would be prepared to re-examine prior challenges. So I'm being affirmed because I didn't hold a hearing when I did, and a conclusion that I didn't make. Point three, that no hearing was necessary because of the intrinsic reliability of the fingerprint analysis, ACE-V. I did not believe that that was intrinsically reliable, but I never got to that because the lawyer had waived a hearing. So essentially, I was affirmed by the First Circuit Court of Appeals, 3 judges, that was essentially completely inconsistent with what I had done. And it was almost as if it was a sort of automatic response to a judge's exercising their discretion. As I said, I completely disagreed with this, but I was hardly in a position to disagree when I was affirmed. As a result of that experience, I issued an order that in every criminal case, every case that involved trace evidence, the admissibility should not be presumed, that it had to be carefully considered and tested in the light of the NAS report, the concerns of the case law, and Rule 702 of the Federal Rules of Evidence. In other words, I issued an order saying, I'm going to do this in every case. This will be my institutional response to the National Academy report, my institutional response, so that essentially Pena wouldn't happen again. There will be a hearing. Not much happened as a result of that, in part because federal cases really typically don't involve this kind of evidence. Not much happened at all. I was touted all across the country, but not much happened in my courtroom. But this, as I said, was my institutional response to the National Academy report. So what's the reason for that? How does this possibly happen? One is a problem of advocacy. And one is an issue of timing. If a lawyer doesn't raise these issues in advance of trial, they are raised during a trial with a jury sitting there and a man on trial for his liberty. And when it's and as I'll describe in a moment, when that's a setting of knee-jerk reactions, that is not a setting in which there will be a careful consideration of the evidence. That is a moment, you may be even a tutor judge, even somebody who had the experience that I had, that is a moment of extraordinary, likely to be very difficult for any judge. What is your intuitive knee-jerk reaction? Also, what's the difficulty of sitting, particularly in a violent crime case, when that's raised mid-trial, when the victims are sitting in the back? It is not necessarily a setting for dispassionate review. There's a resource problem. Private counsel, the CJA private counsel is lawyers that are appointed by the court and get money from the court have very limited resources. Very limited resources. The government has very substantial resources. Public defenders don't have substantial resources, and private lawyers who are appointed per case don't have substantial resources. So what you see is that forensic evidence is challenged much less frequently in the setting in which it is most important, which is when liberty is at stake. I talk about civil criminal problem. I'll get to that in a minute, but what that means generally is you find substantial challenges to evidence based on the expert testimony rules on the civil side where money is involved. Where money is involved, and there are well-heeled defendants on both sides. Problem of advocacy is also related to the problems of defining what comprises effective counsel. And just as the trial courts have lagged in taking the National Academy report seriously, the law about what's the standard for advocacy has lagged. So it's a very low bar. I've forgotten who it was, Stephen Bright, I believe, who does death penalty work, describes the bar for ineffective assistance of counsel as the breath on the mirror standard. Is the lawyer alive? And if the lawyer is alive, advocacy was appropriate. So what you don't have is a robust law requiring lawyers to do what the lawyer in Pena did not do. There's not, and so there's a problem of advocacy, the timing of these challenges, resources that are available, the standards. And the Pena case was a classic example. But I want to tell you about another case in which this was clear. United States v. Hebsche was an arson case. A man who had a five and dime store that was on the first floor of a building was accused of setting fire to the building for insurance purposes. He owned the building, he would get insurance for it. The motive was lame, that he was out of money and that this was for financial purposes, but the man had no criminal record. There was no reason to believe that he would have done this from anything in his background. A critical part of the evidence was the arson dog. And I hear nothing about this case until the day the trial begins. Again, the timing, the lawyer didn't file any motion in advance. I don't know anything about the case except the charges, and it's going to trial on Monday. We select a jury. The lawyers are experienced lawyers. Case begins, the first witness is the dog handler. The dog handler takes the stand and he starts talking about Billy, the arson dog. Billy and I know each other well. Billy and I train together. He comes home with me, plays with my kids. I train him during the day. We train him as an arson dog. Billy went to the site of the fire, went to a particular corner of the room and snorted in a way that I understood to be a sign that that's where the fire began. I'm hearing this testimony cold. I said there was no pretrial review of the testimony. That's just that. At that point, it was about 9:45. I stand up I turn to the jury and think, I'm going to give you a break at this point, a coffee break. They'd only been sitting there for maybe a half an hour. I'll give you a coffee break. The jury leaves the room. I turned to the lawyer and said, are you going to challenge this? And the lawyer says, no, Judge, I'm good. There is nothing I can do. In fact, some would say even my asking the question of him and interrupting his case was itself wrong and getting out of role. But I couldn't envision any set of circumstances in which this testimony was appropriate. The jury comes back in again. The witness takes the stand. And after his snorting testimony, he follows with testimony that the dog wagged his tail in a way that I understood to be a sign. I excuse the jury again. Surely you're going to challenge this. No, Judge, I'm good. You understand at that moment, not only am I not in a position to, I've thought about this case a lot, and I thought about what I should have done. I could have suspended the jury trial and required that he challenge the testimony. That is so far out of a judge's role. I could have tried to examine the issues myself, but I knew that there was an issue here. I didn't know, I was not in a position to cross-examine the witness at all. And I didn't know whether these were experienced counsel who had a strategic reason not to challenge this that I didn't know about. So after I queried the lawyer and he says he's good, witness comes back on the stand, finishes preposterous testimony in my view. Other witnesses based their conclusions about where the fire started based on the dog, the arson dog's testimony, and the case goes on. Mr. Hebsche is convicted. Federal sentencing is very punitive. He wound up with, I believe it was 10 years, 5 years on one charge and 5 on another. I was appalled. The 5 years later, another lawyer enters the picture, challenges the conviction on the grounds of ineffective assistance of counsel. That by the time of the Hebsche trial, we had heard already about, I believe, the Willingham case in Texas of death penalty cases where arson evidence had been wrongly introduced. So by this point, there was a body of literature that was evolving. The question was whether that body of literature existed way back when Mr. Hebsche was tried. The lawyer presents a case about what was known at the time, and I issue an opinion setting aside Hebsche's conviction on the basis of ineffective assistance of counsel. I took to describing the testimony as like a Ouija board. There were uses to which one could put dog testimony, but this had been offered for the truth of the matter, not as a part of the data that another expert might use. When I was looking for cases involving arson, I could find none on the criminal side, no criminal case in which a judge had written an opinion examining arson testimony and excluded it. I found lots of opinions involving insurance companies who were suing homeowners when their houses burned down. Usually the homeowner sues the insurance company for not covering the fire in which their house was destroyed. And then both sides hire experts, arson experts, and courts on the civil side, when money was involved, issued opinions excluding this testimony. But what the takeaway is, I found no examination of this on the criminal side in criminal cases, but many when money was involved on the civil side. I began to look more closely. It was a problem not only of advocacy, it's a problem of judging. There's an ideological problem with district court judges and biases to some degree. Most district court judges are former prosecutors, state and federal. It's changing now. And there is at least a concern about upending a criminal prosecution. not necessarily putting my finger on the scale of the government, but certainly many judges begin with a concern about upending the case that the government is offering. The pressure of a criminal prosecution, I don't think anyone can deny. There were no victims in the Hebshi case except the insurance company, but it is very difficult to say in a case, this one piece of evidence, forensic evidence, is suspect. I'm going to exclude it, knowing that the defendant may then walk away. I was a criminal defense lawyer. I was more sympathetic to defendants in a situation like that, but even I understood the significance of a criminal prosecution. So there's a ideological, it's not clear that the scientific examination is taking place on a level playing field. There's the media. No judge is ever criticized for affirming a conviction or allowing evidence to come in that they shouldn't. The media is 100% sort of a drumbeat for criminal prosecution. Trial courts are busy places. A judge will be making decisions in a trial setting very quickly. Even in a pretrial setting, very few trial court judges write opinions. And why does that matter? I'll get to that in a minute. So there was US v. Green was just one of the cases. US v. Green is a death penalty case, a federal death penalty case, extremely unusual. The defendants, which are well-heeled in death penalty cases, the Zernayev prosecution is a classic example. The death penalty defendants get a kind of resources that nobody else gets. And there was a challenge to ballistics testimony in the Green case. The expert gets on the stand and testifies that this particular bullet that was found at the scene came from the defendant's gun. I didn't know very much about ballistics evidence, but I knew to be a critic. The lawyer cross-examines the witness. Well, ballistics evidence, tool mark analysis is what this is. You can say there are lots of marks in a gun when a gun is fired. One mark is unique to the manufacturer. One mark might be unique to the gun. And then there were marks that really could not be attributed to anything. With respect to the mark that was unique to the manufacturer, the witness was asked, do you have pictures or records from the manufacturer from which you can compare this gun to? No, I just have been doing this for 40 years, he says. I just know which marks belong to the manufacturer. Well, what about marks unique to the gun? Well, we test fired it, so I can do marks unique to the gun. How do you distinguish between aberrant marks and marks unique to the gun? I've been doing this for 40 years. Defendant cross-examines him. I am very, very troubled by the evidence. Were there pictures that were done of your comparison so that we can go back and look at what you did when you first received the evidence? No, I don't have any pictures. I've been doing this for 40 years. I wrote a decision essentially reflecting how troubled I was by the testimony. It's a death penalty case. By that point, I had had two other issues that had gone up to the Court of Appeals in which they had reversed me. One was trying to change the jury selection, and I was reversed. The other was setting up two trials in a death penalty setting, one trial with one jury on liability and one trial on punishment. I thought I had the authority to do that. Different juries, two trials. I'm reversed. Candidly, I wrote this in the opinion, I feared that if I excluded the ballistic evidence, the Court of Appeals would find some way to remove me from the case. They would be wrong. There would be no basis. But once that would be done, there would be no undoing it. So I wrote this decision describing what was wrong with the ballistics. And I concluded that I would allow the ballistics experts to testify, but only on the condition that what the ballistics evidence experts said was, I'm only in a position to evaluate the similarity of the marks. I can only tell you that this mark looks like the marks I've seen in the gun that I'm in the shell that I'm comparing it to. I cannot conclude that this shell belonged to this gun to the exclusion of all others in the world. In fact, I wouldn't let the expert even conclude that it belonged to this gun, only that it was similar. It was an effort to try to restrict the testimony, in my view, to the only thing that was remotely legitimate about this expert, which was his experience. On reflection, I wish I had excluded it. Ultimately, there was not a conviction in this case, but on reflection, I wish I had excluded it. United States versus Hines. Again, I had written an opinion, which is why the Pena case was so remarkable to me, because it was clear, everyone knew I was prepared to look carefully at these cases. Hines was a case of a bank robber, addicted bank robber, comes in with his fingers in his pocket. He writes a note at the table before he goes up to the teller, and then decides he doesn't like the note. He scrunches it up, throws it in the garbage can, and then he goes up to rob the bank. And this was one of those cases. He robs the bank, he gets a certain amount of money, he walks outside. He's then picked up several days later. He's driving his own car, etc. At issue in the case was a handwriting on that crumpled up note and eyewitness identification. The defendant, the case went to trial initially, and the defendant really did not offer any expert testimony on the eyewitness identification issue. He cross-examined the government's witness on the handwriting. The defendant the jury hangs. It means they can't come to a decision. The second trial is in the offing. The defense wants to introduce the testimony of an eyewitness identification expert, social psychological evidence about the limits, the problems with eyewitness identification, cross-racial, when you're under stress, essentially the memory research applied to eyewitness identification. It had been admitted in other cases. It was a legitimate field of inquiry, experimental basis to the conclusions. The experts were not saying this eyewitness identification was bad, but talking about the framework for evaluating eyewitness identification. In addition, the defendant wanted to exclude the fingerprint testimony. So eyewitness identification, they wanted an expert. The fingerprint they wanted to exclude. I wrote a decision in which I said that I will allow in the eyewitness identification expert. That was a real expert, a social psychologist who would say, here are what my experiments have shown, not saying whether this identification was good or bad. I would allow it in. With respect to the handwriting, I said, this is tremendously problematic. The most the witness could say is this squiggle matches this squiggle, but he cannot draw any conclusions. The case ultimately, Green resulted in acquittal. Hines, the defendant, pled guilty. What is the difference between what lessons can one learn from what I did and what I'm describing about judges in general? Green and Hines, I had the opportunity to evaluate the forensic evidence out of the context of a jury sitting there. I could evaluate it in a deliberative setting, and I could ask for whatever research I wanted to ask. So I cited Kahneman and Tversky, talking about cognitive biases, the difference between decisions that are made in the heat of trial and decisions that are made before trial. So if a lawyer doesn't raise these issues before trial, but only raises them in the heat of trial, not a surprise that the results are different. anchoring, the impact of heavy reliance on initial information or impressions. With respect to forensic evidence, that means, well, we've been allowing this stuff in for the past, 40 years. Why not? The pressure to upend the existing assumptions about forensic evidence is dramatic, not to upend it. The tendency to rely on information that readily comes to mind, again, more likely in the trial setting than in the pretrial setting, but still a problem with it all. Difficulty of organization self-correcting, judicial education. The National Academy report could be presented till we're blue in the face, but to the individual judge in the individual courtroom, if he's allowing fingerprint evidence for the past 20 years, undoing that is extraordinarily difficult. And then a status quo bias, which is essentially what precedent is. The pedigree of forensic evidence, fingerprint, handwriting analysis is substantial, been introduced time after time again. Why should I reconsider it? So it's a problem of judging at the trial court level in the ways I've described. It's also a problem of judging at the appellate court level. The evidentiary issues, when a judge makes a ruling on evidence, the review is based on abuse of discretion. Now, the way it was described by one court, this has changed a little bit, is no conscientious judge acting intelligently could honestly have taken the view expressed by the trial judge. That standard essentially encourages judges to let stuff in that has always been let in. So no conscientious judge acting intelligently could have taken the view expressed by the trial judge. The judge had to be laggard, dumb, and dishonest to be reversed. It creates a powerful incentive to not do anything different. While no abuse of discretion finding, that's what a court of appeals is saying, means there was a range of acceptable decisions, right? There was allowing it in. There was the Gertner limitation, maybe even excluding it. There was a range of discretion. It was reasonable. You were in the reasonable range, and therefore we're not going to overturn this conviction. The problem is that that finding is then used by the prosecutor in the next case to say, not the judge who allowed in fingerprint, ballistics, et cetera, didn't abuse his discretion, but it will turn into, therefore, this evidence is fine. The message that gets communicated by the affirmance of the conviction is a message that will be, this evidence is fine. On the appellate level, the more that we excuse error, there's a concept in the appellate courts known as harmless error. So that is, you're wrong to admit the evidence, but on balance, no big deal. And what I'm actually examining now in my writings is whether the habit of excusing error in case after case after case makes it difficult for the Court of Appeals to even identify it. If you have now allowed in fingerprint testimony under whatever set of circumstances, handwriting, ballistics, and then what happens over time on an abuse of discretion standard. Judge, it's always been allowed in, will continue to allow it in. Judge didn't abuse his discretion. I wonder whether the habit of excusing error actually keeps a judge from identifying it when it is there. You have to say, you may have allowed the evidence in last week, but this time is different, and that becomes very difficult to do. I believe that appellate judges have difficulty even envisioning error. Very few of them have been trial lawyers, so these issues are given short shrift on appeal. Witness U.S. v. Pena. Given such short shrift that I was affirmed for doing what in fact I hadn't done. There's no accountability. Evidentiary issues are fact-bound. The Supreme Court rarely grants certiorari. So there is a vicious cycle here. The vicious cycle is the pedigree of trace evidence the fact that it has been admitted without objection for decades, creates a disincentive to challenge it. And that was partly what was going on with the arson dog. Why bother? These challenges have lost over and over again. Why bother? If you have limited resources, I'd rather focus on this witness rather than on the arson evidence, especially since there's precedent for admitting it on the criminal side. So why bother? The Fry standard, I don't know how well people know the standard for evaluating expert evidence before this Daubert decision had been a case called Fry, in which it was the general acceptance of the community. That was the standard. Judges were not going to actually evaluate testimony to look at validity and reliability. In a sense, they were just taking a vote. How many people, how many people think this is appropriate evidence? Acceptance in the community. Well, when you have evidence that has been admitted without careful examination for years and years and years and years, there is likely to be a community that finds it acceptable. The Daubert standard required judges to look at the reliability and validity of the evidence if a lawyer brings a motion. The Daubert standard was going to require a judge to evaluate, look at the proficiency of the expert giving the testimony, not just the scientific reliability and validity of the field, but also the proficiency of the expert giving the testimony. But Fry is still the law, which is, as I said, just a vote about acceptance in many jurisdictions. And even judges that are charged with being a much more robust gatekeeper don't do it. The pedigree of trace evidence, the fact that it has been admitted, basically is a disincentive. In addition, you know that if you allow it in, given that pedigree, you won't be reversed. And the Court of Appeals then doesn't reverse. And so the cycle continues. If the lawyer doesn't tee up the issue, it's admitted without objection. The lawyer doesn't raise the issue. If the lawyer does raise the issue, I object to this. Oftentimes a busy trial judge will admit it, counting on the precedent and the dearth of meaningful appellate review. In all the cases I've described, the path of least resistance would have been allow in the arson dog, as I had to do ultimately, allow in the fingerprint test, allow in the handwriting analysis, allow in the fingerprint testimony, the handwriting analysis. And even if I had doubts, odds are I'd be affirmed, and odds are I'd be affirmed. So there's no incentive for lawyers to challenge the trace evidence because of these issues. If the lawyers don't tee up the issue, as I said, a busy trial judge would admit it. If the appellate review is empty because they're likely to be affirmed no matter what they do in this area. Of course, it's ironic that DNA, new science, was in fact subject to substantial review when it was initially introduced, but not the existing science. National Academy report totally trashed bite mark evidence. And yet there are cases around the country with judges saying, well, that's not before me. That's the National Academy. I'm not bound by that. And of course, they're not bound by that. I will make my own decision. In one sense, what you see is a very decentralized decision-making structure, individual judges and individual courts. These reports could bear on that decision-making, but doesn't bind them. And unless courts of appeals are willing to say, there may be an abuse of discretion standard, but this is wackadoodle, and that's a legal term. I mean, this is just going too far. This is just going too far. Why bother to challenge the evidence? And that's what I saw in the cases in front of me. So what's the future? Judicial training. But we've been training about the National Academy report and the PCAST report for some time. There's a wonderful story about one training that I went to in which the scientists were trying to show the limitations of some of the evidence that was being described. The limitations on the basis of scientific validity of some of the evidence being described. a judge in the back raised her hand and said, you know, I really don't consider any of that. I listen to the witness, and if I find him credible, I allow the evidence in. At which point the scientist who was doing the presentation said, you know, snake oil salesmen were really, really credible. The judicial training, but judicial training needs to be at the appellate level. Judges have to be told that there are, if evidence is not within the zone of the scientifically valid and reliable with appropriate proficiency testing, it ought to be excluded. And until those exclusion comes from the Court of Appeals, district court judges will play the odds. Lawyers will play the odds. Implication of the innocence narratives, again, we talk about that all the time, in which trying to get judges to envision error. I'm a member of the Massachusetts Forensic Science Oversight Board, which may make a difference in the sense it's a board that is dealing with coming to conclusions about the reliability of certain kinds of forensic evidence. We talked about familial DNA in our latest report. We're trying to come up with an accreditation system for officers who are giving this kind of testimony, experts who are giving the testimony, but we don't bind the individual courts. We don't bind the individuals. To be sure, if we dealt with bite mark testimony and said there was actually no basis to it whatsoever, a court then that allowed it in, that may well make that decision vulnerable. That may make that decision vulnerable, but we don't know. Again, it's a decentralized system. And the question is, how do you break the cycle I've been describing? I think about people writing critical evaluations of what judges do, newspaper criticism of what judges do, changes the implication of who we should put on the bench. But it's a stunning story of the resistance of the bench to the scientific community. Because the scientific community, as embodied in the National Academy Report, as embodied in the PCAST report, could not have been more clear. And judges' response is, I don't have to. You don't buy, I'm not bound by it. And that's true. So I want to sort of conclude by just urging that we all look at this again in terms of who we select for judges, in terms of courts of appeals. It just makes no sense to decry wrongful convictions, as we do regularly in the media, but to wrongful convictions based on forensic evidence, but continue to allow it to be admitted largely without examination. It makes no sense to be concerned that jurors are holding prosecutors to a higher standard because of this so-called CSI effect, and be less attentive to ordinary evidence. It makes no sense to ignore the standards for admission when liberty is at stake, but apply them when money is at stake. So if this were an audience of judges, I'm sure there would be some group that would say, oh yes, we will consider this carefully. And some group that will say, thank you very much. It was a nice afternoon. And there's no enforcement mechanism until we begin to change the kinds of incentives that I described. So one of the more depressing reports imaginable and lectures, but thank you very much. And I'm happy to take questions.
Thank you so much, Judge Gertner. I really appreciate that. That was a really, really awesome presentation. I received several messages in the chat with questions and other feedback. So thank you so much for sharing your perspective there with us. Lots of thought-provoking things for us to think about. I'm going to read a couple of questions to you, and we're coming up on time, so we might go a bit over 4 o'clock, if that's okay with some people. But first question I have here, from your experience, are more sitting judges former defense attorneys or prosecutors? And do you feel that their background prior to their judgeship makes any difference on how liberal or conservative their opinions ultimately are?
Let me not sort of put this in terms of liberal or conservative, because I don't think that that necessarily maps onto what I'm talking about. If you have been a defense lawyer, then you are used to being critical of, because your job is to be critical of forensic evidence. And so you will then look differently at evidence that is offered. You still can't do very much unless the lawyers are bringing the evidence in front of you. So I'm not sure it's liberal or conservative. It's really a question of imagining that this evidence could be flawed, and imagining that even though you're likely to be affirmed if you let it in, that you shouldn't. So I think it's certainly the outcomes would be different with a defense lawyer, but the pressures are still there.
Thank you for that. Another one, since this is something of a blended audience here, is there anything scientists can do to help improve scientific literacy or comfort with forensic science and judges and/or lawyers?
Well, we have had joint training with scientists and with judges, and PCAST was also led by Eric Lander and had numbers of scientists on the group. The National Academy report was also a mixed group. It's almost as if I want the scientists to say, to not be dispassionate. I want, the PCAST report came very close to saying it. I want them to say bite mark is baloney. You don't talk in those ways, but it's almost as if once you give a judge the opportunity to say on the one hand, on the other hand, that's what a judge will do. So with respect to certain fields, it seems to me that I want the criticism to be, if it's legitimate, to be pointed. And I think, as I said, we have to criticize courts of appeals. I'm not just saying that because I was a trial judge, but unless judges are being reversed for the decisions they make, they will continue to make these decisions. So your work has to come in maybe through amicus briefs at the courts of appeals. This is really important. I do amicus briefs for the Center for Law, Brain, and Behavior, trying to introduce some context into these decisions. So that would be helpful.
Great, thank you for that. Another question, let's see. With regards to the Melendez-Diaz versus Massachusetts case, are there other such forensic examples aside from drug cases that are where a cert report is allowed to serve in place of the analyst appearing to offer testimony?
I'm not sure that I know of other examples. That practice could change, though, after the Boston Crime Lab scandal. Your willingness to introduce a piece of paper may be different after we have now seen that even relatively formulaic tests could have been so distorted. So this is a situation where a judge can allow in a piece of report, but doesn't have to. And if you understand the context, you would make a different decision. It's not required, but it's allowed. And so if they understood the context, they should make a different decision.
Thank you for that. Let's see, just a couple more questions here. Would locally available trainings for judges or attorneys on forensic evidence and analysis and interpretation be helpful? And do you foresee it being accepted in the legal community and as an effort to increase the dialogue?
Yes, I mean, I think that there should be joint trainings of judges and lawyers, but you know, judges respond to cases. And so I wonder if we could figure out a way to have, not after a case is decided, not in the, you know, the throes of litigation, case studies in the way doctors have case studies. Doctors will have clinical rounds about particular cases. And I want to encourage judges to do that. I had a horrible experience a year ago. A man is about to be released in state court, and on an innocence claim, or evidence, not innocent, I guess evidence had been admitted that shouldn't have been admitted. And I talked to one of the members of the Innocence Project, and I said, oh, who is the judge? On the theory that if there's a wrongful conviction, all of the players should get together to figure out how it happened, and the judge included. And she said, you were the judge. I swallowed hard. I took out the papers. I examined what had been presented in the trial court, what had been presented on appeal, and what had been presented to me. I think I honestly concluded that the lawyer hadn't presented any of these arguments to me, the arguments that were later successful. But I think that that's an interesting exercise. If a scientist winds up with a challenge to his data or to his or her conclusions, you go back and you figure out what happened and why that happened. In judges, the only measure of my accountability is, am I going to get reversed? Not was the result wrong. I think that that ought to change. And the book that you mentioned that I'm writing about the men I sentenced is partly my re-examination of those cases, which is giving me a rather substantial bellyache, but that's what I'm doing. But you see, it's a very different model. You really, you want to be accountable to the legitimacy of your results, the outcome, the substantive outcome. Judges are responsible for the legitimacy of the procedures and not necessarily the outcome. And if we change to a different measure of accountability, maybe we'd have a different result.
Wow. Well, thank you so much, Judge Gertner. This was so enlightening and informative and educational. We really appreciate it. I think that concludes all of the questions that I think I see in the chat here, kind of right on time here.
I'm sorry for the phone call. That was from the hospital.
Oh no, we completely understand, and certainly hope everything is okay with your husband. But thank you so much for presenting to us and sharing your time with us and your expertise with us. For those who are in attendance, we're going to share this on our College of Science YouTube page, and we'll also include this on our website in a couple of days. But once again, thank you and congratulations to Judge Gertner. We really appreciate it.
Thank you very much. Take care.
Thank you.